Yes, go ahead now.
Yes, go ahead now. Yes, go ahead now. Yes, go ahead now. Yes, go ahead now.
Okay, sorry for that. As I was saying, conference, and this is the first national conference. And when you look at that name, it simply means that we expect a second national conference. And this is a challenge now to the legal fraternity. Before I present what I had for you today, colleagues, I just want to say something that I've never shared with my dean of the Faculty of Law. And I remember when I was growing up, my ambition was to become a lawyer. And I will tell you why that was my ambition. Because I could really argue with a lot of people. And there was a time that my parents had me arguing with a lot of people. They're the ones who told me, I think, young, when you grow up, you're supposed to be a lawyer. So that is what I had in my secondary school education. But what happened, the greatest that I made was that I really performed well in biology. Because I was selected to go and do biology at high school. So that is how I missed going to the law school. But all is not lost, because I've noted that we have a lot of lawyers who are doctors, a lot of lawyers who are members of the other profession. So what I'm saying is that when I'm done with my tour of duty as the Deputy Vice Chancellor in charge of academic affairs, then I will simply maybe enroll in one of the law schools and become a lawyer in future. So that is a profession that I want to become when I grow up. I just hope all protocols observed, ladies and gentlemen. You've heard my name. I'm Professor Alexander Kahi, and I'm the Deputy Vice Chancellor in charge of academic affairs at Egerton University. As I've just mentioned, I'm not a lawyer. I'm not a learned friend. I'm simply a professor of animal genetics and genomics. So on behalf of the division that I'm leading at Egerton University, I must say that I'm delighted to join you today to really set the pace towards the agenda of strengthening access to justice through legal aid in Kenya. At a time when our legal system is facing a lot of pressure from all sectors of state and non-state actors, it has been more urgent to pool resources to deliver legal aid. I would like to thank the Faculty of Law Legal Aid Project. I'd like to thank Egerton University. I'd like to thank the European Union, the UNDP, and without fail, I must also thank Amkeni wa Kenya and all other players in the forum for joining voice the cries of our legal system that have for long been suppressed. What best way than by assessing the gaps, challenges, access to justice, legal aid delivery. Can you see? It takes more than the players in the legal sector to help steer the boat of justice. And the wide stakeholder involvement gives us hope that in the spirit of collective responsibility, change can be effected in our justice system. I am happy that the civil society leaders in government, us academicians, and non-state workers are all working together in a collaborative and this is a sign of direction justice. Very important.
To interrupt you, we are having an echo from your side. So just a minute so that then we can correct that echo and then we... Oh, okay. Can you kindly check if maybe your phone is on and something else is on?
Let me. Okay. Am I okay now?
No.
Am I okay? Okay. Are we okay? I proceed?
Yes, proceed now.
So I was saying that as we sit down and have this round table on the environment surrounding access to justice through legal aid, it is very, very important to note that the solutions to legal aid lie here within. With constraints of time snapping at our feet, it would be futile if we don't put to practice and make the necessary adjustments to our approach to matters law. As we all make our submissions and all the recommendations that are expected from this conference, let's be keen to put them to work, since we all agree that time is not on our side. Now, in the kind words of Anton Chekhov, knowledge is of no value unless you put it into practice. So, ladies and gentlemen, I hope we all learn as much as we can, and that the output of this session and the sessions for tomorrow, they will be instrumental in helping us cut back on the challenges, in helping us harness the opportunities, and also in helping us seal the loopholes that have for years hampered the fair access to justice among our people. So with those few remarks, let me take this opportunity to thank all of us for attending this conference. And at the end of it all, as I've just mentioned, we expect some very, very good recommendations that I know will be put into work for the betterment of our justice system and by extension for the betterment of this country. Thank you very much, ladies and gentlemen.
Right, we've finally now gotten you. I need to actually clarify that you are a very techno-savvy person and that actually hii mitambo iliyo hapa, it's courtesy of a project that you run at the university. I don't know whether you would like to still talk to the lawyers that you are meeting for the first time here, that you have been telling our law students to also develop a niche towards law in agriculture. I've heard you talk about that several times. I don't know whether you would also like to add that.
Law in agriculture?
In telling students to have an interest in helping farmers and so on and so forth. Now that
yeah, I think you're right. You are all aware that when we look at Egerton University, we started as an agricultural institution, and we've been growing all these years. And when you look at most of our faculties, most of the faculties that were established, they are simply established to support some aspects in agriculture. And I'll give you an example of a faculty that is a little bit far, and I'll give you the reason why we established it. A faculty like health sciences, of course, we know what medics do, but at the end of it all, our argument was that farmers fall sick, and then when they fall sick, that goes a long way in affecting agricultural production. And that is why we came up with the faculty of health science. For the faculty of law, when you look at most of the cases that we have in Kenya, and my learned friends can attest to this, most of these laws, they have something to do with land. And when you talk about land, apart from real estate development, when you talk about land also, we use land for agriculture. Meaning that most of these cases have a direct implication on our agricultural production. So when we talk about the faculty of law, and I've been talking to to our students, and they're very good students. Our first lot, they're now in their fourth year, and what I've been trying to encourage them also to think about matters agriculture, how agriculture is related to law, and how law is related to agriculture. Because at the end of it all, when you look at our economy, we always say agriculture is the backbone of our economy. And if that is the case, then we should really within agriculture, all universities will work towards improving agricultural production in this country. So the faculty of law was not really left behind. And when we look at the focus, they always focus on human rights. If you don't have food, there is no human right. So when I look at the way the faculty law is organized, the way it is arranged, I think it is really consistent with our core mandate, with the core mandate of Egerton University, which, as you all know, was to ensure that we improve agricultural productivity. So that is what I'd like to say. But I'm really happy to be part of this forum, and I'm happy to be speaking to now the learned friends, because I've been speaking too much to the learning friends. That's what I was told they are referred to. But I'm very happy that I'm speaking to the learned friends, and this is a very good opportunity for us to work together with the legal fraternity. Thank you very much, MC.
All right. Asante sana, Professor Alexander Kahi, our DVC Academic Affairs. And I can just tell you that your team is doing a wonderful job here. All right. And asante sana. Okay. Unfortunately, there is no way you can follow us through. You can not really follow the proceedings here, but we can follow you from the office. So maybe if you can, you can continue remaining online and see the rest of the presentations at least for the day. But that will be at your pleasure and leisure. Thank you so much for now.
Thank you.
Gentlemen, we are going to move on to our next presenter for the day. And that is a gentleman who will also be doing that, the presentation online. He's doing it from South Africa. And he's supposed to be sharing with us the legal aid context from South Africa, or rather the South African legal aid context. His name is Dr. Mataiwa Busieka. He's actually Kenyan, but works in South Africa. And if you look at the program, he's the director of programs in South Africa. If you look at your programs, his presentation is titled "Challenges of Access to Justice for Gender-Based Violence Victims, South African Perspectives." So we are going to get So once we get him online, we are going to just straight away listen to his presentation. That's not from our side, it's from his side. So once he unblocks his camera, then we are set to go. Dr. Busieka, let's just assume that he's doing that not by accident, but
Yeah, I don't know what it is, but there's something wrong. Yeah, but can program director. Can you hear me there?
the first problem is that your camera is blocked somehow. So we can't see your face unless you don't intend us to see it.
Yeah, I don't know what the problem is, but if you can hear me, then I can share my screen and start making the presentation.
We can hear you, but the other thing is that we just hope that only one of your equipment is on. Okay? So just share your screen then, and then you can go ahead. The unfortunate thing is that we will not see your face and put some voice to the face. Or is it put a face to the voice?
I don't know why the camera is behaving like that, but what I can do
Screen.
my phone. Let me log in on my phone. Then you can see me while I'm presenting on the computer. Is that all right?
Problem with the echo. We just need one equipment to be on. Mute one. Microphone. Is on here.
Can I present? Can I present through my my presentation? Program director, can I present?
Yes.
Yeah, it's my presentation on the screen. Program director. Hello, my presentation on the screen. Program director, I can't hear you.
Just share your screen and do the presentation.
All right, thank you very much. Okay, I'll do that. Is my presentation on the screen, program director? I just want that confirmation.
The presentation is on the screen. Go ahead.
All right, thank you very much. Yeah, thank you so much, participants. I just want to thank the university leadership for this invitation. More especially, I want to thank my alumni, Dr. Ruth Aura. I was with her in class during our law school studies. My names, as you've heard, are Matayo Busieka. I work for as the South African government in the international relations environment. And I want to say all protocol observed, and I'll proceed with my presentation. As it has been introduced, my presentation will focus on the questions of the access to justice for gender-based violence victims, and I'll have this as a perspective of the South African experience. In this regard, my presentation outline is to look at a background setting, and then I'll go into to look into the barriers to GPV access to justice, and then I'll look at the GPV mitigation measures during the COVID, because as we know, COVID presented an additional strain on the GPV access to justice. Then I'll also look at the international jurisprudence on GPV, just to make a basis for municipal law for the access to justice for gender-based violence. And then I'll look at the infrastructure on gender-based violence access to justice, what do we have in South Africa. And then I'll go into a discussion of the inadequacies in the justice system, what are the prevailing injustices, and then I'll conclude. Chair, if you don't hear me or anything, just alert me, because I'm assuming that you can hear me well, and the presentation is on the screen. Now, ladies and gentlemen, colleagues, women access to justice, as we have heard from previous speakers, is important for the basic reason that it consists of the intersection between three foundational human rights principles, which the DVC has just talked about and linked it to food, which is very interesting. And these are the human right not to be subjected to torture or ill treatment. The other one is the human right not to be subjected to discrimination on grounds of gender. And finally, the right to a remedy for violation of those rights. So this is the basis of ensuring that gender-based violence victims have access to justice. Now, just a brief background, because I'm summarizing a paper, a full paper. I'm just putting in a quick summary. Gender-based violence is a profound and widespread problem in South Africa, as indeed the entire world, impacting on almost every aspect of life. And of course, GPV, which is disproportionately affects women and girls, is systematic and deeply entrenched in institutions, cultures, and traditions in Africa. That much we know. The persistence and prevalence of violence against women has been described by the UN Women as a pandemic and by the World Health Organization as a public health problem of epidemic proportions. And this contribution will focus on GPV's access to justice, like I said earlier. Now, let me look at the barriers to access to justice for gender-based violence victims. Now, the legal and procedural barriers to GPV access to justice are, of course, one of it would be the problematic interpretation and implementation of the law, which discriminates against women. And of course, we have the ineffective or problematic legal procedures, such as the lack of gender-sensitive procedures in the legal system. And we have poor accountability mechanism, including corruption, underrepresentation of women among legal professions or professionals. And finally, on this aspect, you have discriminatory laws customary systems in some jurisdictions, not all of them. So what are the socio-economic and cultural barriers? Those are the legal and juristic barriers, but we have very specific socio-economic and cultural barriers that even inform the judicial barriers that I've just mentioned before. One of them is lack of awareness of one's legal rights and legal procedures, or of how to access legal aid, which can stem from gender differences in educational levels, access to information and all that. And secondly, you have a situation where there's lack of financial resources, including means to pay for legal representation, legal fees, judicial taxes, transportation to courts, childcare, etc. And the unequal distribution of tasks within the family. And finally, gender stereotypes and cultural attitudes. All this constitutes the barriers to access to justice for GPV victims. Now, there are mitigation factors or measures during the COVID that were prescribed because of the special circumstances that were presented by the pandemic. And because, as we know, during the pandemic, there was even an increase, a sharp increase in gender-based violence. And maybe because of the confinement of people, and many courts, like in Kenya, for instance, courts were closed, and there was restriction on going out, and people can't report to the police or to other justice sectors. So that then prompted the UN to develop certain guidance which would help the GPV victims, or help government to implement those measures. Now, and that the sharp rise was recorded throughout the world. It was not just specific countries. So one of these is provide policy, and of course we are still in the COVID scenario now. It's not gone away. It may get worse. So one of it was to provide policy advice to governments on integrating GPV in national and subnational COVID-19 response plans. The other one was support police and justice actors to provide adapted services during periods of confinement or lockdown. The other was to adapt and expand services such as shelters, safe spaces, and essential housing, along with psychosocial support and advice for individuals experiencing or at risk of GPV. And of course, there was the issue of addressing GPV risk factors in socioeconomic assessment and response, and engage and empower partners to send a strong message that violence will not be tolerated, perpetrators will be punished, survivors are available, and everyone has a role to play. And then promote GPV response, health systems strengthening. And finally, do no harm by ensuring that interventions do not reinforce existing power imbalances, which not only underpin GPV, but also undermine broader social cohesion and sustainable recovery. So basically, these are some of the guidelines that were prescribed for mitigating the severity of GPV during COVID. So let me move on to the international jurisprudence on GPV access to justice. Those broad principles say. Now, generally, we have equality is an underlying value of international law, and all major human rights treaties contain a prohibition on discrimination on the basis of sex or gender. And guaranteeing women's equal access to justice is also one of the 6 priority themes of the Council of Europe's gender equality strategy. And we had our friend from the EU emphasizing some of these underscores. And of course, the gender equality standards pertaining to equal access to justice for women are addressed by a variety of standards and grounded in 4 major treaties of the Council of Europe. And we have finally jurisprudence, particularly sheds light on the attitudes of prosecutors and the judiciary in failing to take account of women's entitlement to protection of the law where violence takes place in families. So I'm moving to the local or municipal law, and one would obviously want to know what is the interface between the international and the national law as pertains to issues of access to justice, in this case for gender-based violence. Now, we do know that key international instruments on access to justice, part of them are the European Convention of Human Rights and Protocol number 12 to the European Commission on Human Rights. And we have the European Social Charter. We have the Convention on Action Against Trafficking in Human Beings. And finally, you have the Convention on Prevention and Combating Violence Against Women and Domestic Violence. That was an Istanbul convention. And apart from that, we have heard about the work of NGOs, and it's an excellent work, and it's a very important work because they are grounded in communities and they understand community challenges. So that's why we have feminist lawyers have also developed jurisprudence by bringing cases of violence against women through domestic legal systems, and where they still have not received justice, they have brought these cases to international and regional human rights adjudication. For example, the Committee on the Elimination of Discrimination Against Women, and to the European, African, and Inter-American Human Rights Records. And that was said by Mlambo Nkunka, the current director on in the UN of Women, UN Women, the one we just seen in the middle there. And she was the former vice president of South Africa. Now, let me move to international precedents on GPV just briefly. One of it is we have a case of Maslow versus Russia in 2009, where the court held that the manifestly debasing character of rape emphasizes the state's procedural obligation in this context. And then the other one is the Hajova versus Slovakia in 2010, where the court held that authorities may act ex officio, and let's emphasize this ex officio, sometimes even against the expressed wishes of the victim, just to protect the victim. And you have the case of Kontrov versus Slovakia 2007, where the court held that national authorities have a positive obligation to take protective measures to prevent domestic violence when is knew or ought to have known at the time of a real and immediate risk to the life or health of an individual. And finally, so the other one is that of Pavel versus Bulgaria 2008, where the court held that in some cases, temporary emergency protective measures may be taken. And finally, we do know that judicial remedies are available, and demonstrated that judicial remedies that allow a victim of domestic violence to escape the violent situation through inter alia divorce or separation proceedings must be accessible and effective in order to guarantee practical and not just theoretical or illusory protection to a victim of a vulnerable position. Now, I'll quickly also look at the threshold for access to justice that lay basis for some of these things. One of it is that there has to be justifiability, free and equal laws available of justice mechanism, good quality of justice provision and accountability of justice systems, independent and good quality judiciary free from corruption, bias or stereotyping, providing timely and efficient remedies. And then you have the equality is enshrined in the law, whether criminal, family, personal, status law, civil law, administrative or public law, so that women can freely seek justice on their own terms without having to seek permission of anyone, and have the same access to legal processes such as divorce, child custodies, and all that, as the same as men. And of course, a requirement for specific definition of crimes, especially relating to sexual violence, which protect women's and girls' physical and mental integrity, personal sexual autonomy rather than moral order, or the entitlement of a man to sexual contact with his wife without her agreement. And obviously you have the requirement for social services such as hotlines, advice centers, and provision of information for that, so that women can be empowered to seek justice. And an end to impunity of perpetrators. This is emphasized all the time, to ensure effective deterrence, particularly in cases of so-called honor killing, the phenomena often referred to as crime of passion or provocation in Europe and the Americas. And finally, the necessity of civil protection orders, measures to protect victims' privacy, gathering of data to ensure that women are able to access justice in equality with men. And data is an issue, a theme that has recurred in various speakers I had that spoke earlier, that some of this is lost because we do not have the capacity to capture what is happening on the ground, especially in mashinani. So let me then move to jurisprudence on GPD as a South African perspective. Now, general principles to gender-based violence access to justice in South Africa are, of course, enshrined in various instruments. Like, of course, we do know that South Africa is aware of and has aligned its systems and procedures to adhere to the standards developed through the case law of the European Court of Human Rights in cases of gender-based violence. And some of these, Article 4, where we want us to institute measures to protect the rights of victims of violence and secure this without discrimination, exercise due diligence to prevent, investigate, punish, and provide reparation for acts of violence. That's Article 5. Article 15, provide adequate training of professionals working with the gender-based violence victims on their needs and rights and on equality, and ensure that investigations and judicial proceedings are carried out without undue delay, Article 49, and finally, facilitate for prosecutors to initiate and continue proceedings even if the victim withdraws from the complaint, Article 55. And we know the withdrawal is a very serious and a very disturbing theme that comes through every now and then, and a frustration to the justice system that wants to ensure that perpetrators are punished. Now, what are these constitutional foundations for the South African intervention? Section 34 of the South African Constitution states that everyone has the right to have any dispute that can be resolved by application of law decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. And over the past 25 years, South Africa has made advances in ensuring that access to justice becomes a reality to all South Africans, including gender-based violence victims. And South Africa's success include the establishment and funding of Legal Aid South Africa. And we heard so much about legal aid before, which was laid bare by various speakers. And this specific one also ensures that the destitute have access to legal representation. I'll get into that just in a little while. And of course, the justice sector in South Africa, like its counterpart elsewhere in the world, has a significant role to play in addressing the scourge of gender-based violence and facilitating access to justice. Let me continue. My screen had frozen, but I think I'm fine now. Brief look at
that you kindly start moving towards the conclusion.
concluding soon. This is just the machinery around gender-based violence as it is in South Africa, where you move from courts, police, society, then you have all these support systems that come through. And I also wanted to look at judicial reflections on gender-based violence. You have the court that highlighted that the Constitution imposes a on the state to protect the right of all persons to free from violence. And then judges do not end. And there's this influential constitutional court judge who retired recently, Justice Cameroon, who said that judges do not enter public office as ideological virgins. They ascend the bench with built-in and often strongly held sets of values, perceptions, opinion, and prejudices. And those are the prejudices that one would want to look at. And jurisprudence dealt by the South African courts offers gender-sensitive and socio-political approach to cases and interpretation of legal and other instruments. Okay, I'll skip this because these are some of the judicial precedents that have been set with regards to access to justice. I just look at the middle one, Justice Meyer, who said that while there has been a marked ideological shift in the way judges adjudicate matters of gender-based violence and femicide in recent times, the fate of these victims should not be left to the off chance that the individual judges hearing their cases will be attuned to the sensitivities. There should be a formalization and standardization of these norms so that it is incumbent on the courts to pay particular attention to the treatment of victims. So she's advocating for standardization, not just for individual judges to decide what each other case is on about. Now, with regard to the infrastructure, as the country grapples with the gender-based violence, South Africa has prioritized new courthouses with fully fledged services that exclusively respond to gender-based violence and its repercussions. Already 84 magistrates courts have been established, but the specific feature of this court is that it has got high-tech courthouse, is also a victim-centric sexual offense court. Some of the features are that this court model offers a catalog of victim support services designed to make the court experience informative, comforting, caring, and easy to navigate with minimum help. And more essentially, the courts serve a range of it has a range of services like court preparation for pretrial containment, private waiting room service, private toilet, private testifying service, intermediary service, private kitchenette, travel and food allowance, and post-trial containment. So these are some of the features, unique features that are there. Now, there, of course, as I got into conclusion, I think this is my last slide before I conclude, program director. There are inadequacies, quite serious inadequacies. One of it is that women survivors of sexual violence are frequently confronted with the unsympathetic and hostile treatment from the health services, police, prosecutors, and often judicial officers. Investigations and medical examinations are not thoroughly and effectively conducted to ensure successful prosecutions. Unreasonable delays and withdrawals of cases are a common occurrence, which have a negative impact on complainant witnesses. Judicial officers routinely fail to effectively implement legislative provisions relating to bail applications, rules of evidence, and sentencing. And the extent of the harm suffered as a result of the gendered dimension of sexual violence is underestimated, resulting in the absence of a gender-sensitive approach to criminal prosecution of rape cases. And finally, Reconciliation and other alternative methods of dispute resolution are encouraged as opposed to legal intervention resulting in successful prosecutions. So I conclude, Program Director, by saying that one, there's a need to amend domestic law, ensure that acts of violence against women are properly defined as crimes, and that has been featuring through the various international jurisprudences that we looked at. And then we need to ensure appropriate procedures for investigations and prosecutions, and that is an area of weaknesses. And lastly, we need to ensure access to effective remedies and reparation. That has been a problem. I want to thank you, Chair. That's my presentation, my input. Thank you so much for listening.
Thank you so much, Dr. Busieka, presenting from South Africa. We've gotten you clearly on that. Now we are going to move on to the next presentations. And let me inform you that we have kind of disrupted the program. Most of the presentations that we were going to have today are going to be done tomorrow. We are going to just have 2 more online presentations, and we are done with online presentations, so that then tomorrow we have now speakers here such as Professor Wabwile, Eric Masafu, Dr. Charles Kamala presenting tomorrow. All right. So as we usher in Commissioner Winnie Lichuma to do her presentation on legal aid and access to justice, agenda analysis of the Kenyan legal framework. So as we usher in Winnie, I've just realized that there are mosquitoes that have since visited the room, and we need to chase them away, okay? So let me come here so we can chase the mosquitoes. Technical guys, once you are ready with Winnie, you tell me. You know, long time ago, when animals had the power to speak, Chinua Achebe says that the mosquito went to the ear. This is the story of why mosquitoes like stinging the ear. So the mosquito went to the ear and told the ear, "Oh, you know what? I would like to marry you." Then the ear looked at the mosquito and said, "Look at you, such a flimsy thing. You are even going to die tomorrow." So the mosquito waited for tomorrow, and it did not die. So it came back to the ear and told the ear, "I am still alive, and I want to marry you." So that is why every night the mosquito comes to the ear to just remind the ear, "I am still alive, and I'm ready for marriage." No, we need to chase away mosquitoes from our ears, okay? So when I say mosquito, you kill it, because it's buzzing over your, okay? So when I say mosquito, you kill it, huh? Mosquito, you are not killing it. You are just chasing it away. You need to kill it. Okay, so let's go. Mosquito. Are we ready with Winnie? Okay. She's on? Okay. Winnie, can you unmute your mic? Kindly unmute your mic. After these presentations, you realize that we seamlessly moved on to the paper presentation so we can put the plenary discussions together. And after these, perhaps 1 or 2 presentations, we are going to have now an overall plenary discussion, which is going to be led by Professor PLO Lumumba. So just keep noting the issues that are coming out from all these presentations. And kindly, Winnie and any other person will be presenting, because now we have seamlessly moved into the paper presentations. We only have 10 minutes, not more than 10 minutes. Just do the highlights of your paper. but we can't see her video. Okay, I see that the digital natives are tweeting. Just keep on tweeting. The hashtag, remember, is Legal Aid Conference. Emmanuel Munene has tweeted. Kezia Njoki, D. Nyokabi, J. Muinde Njoroge, yeah, tweeting. Robert Mutembei too. Tim Wafula, Florence Shako, Ndindi Nganga, Tim Wafula. These are the digital natives. And Shona Jua responding to a tweet by Florence Shako. Thank you so much. We are yet to get her. So let's. Which one is it? All right. As we sort out the video, she's ready. Florence is ready. Okay. It's okay. Just leave your comp there. Just leave your comp there. So instead of having Commissioner Winnie Lichuma, we are going to have Florence Karimi Shako, who's also presenting online. The title of her paper is Promoting Access to Justice as an Integral Part of the COVID-19 Response in Kenya by Legal Aid Actors. This is a presentation from Riara School of Law. Over to you, Florence.
Good evening. I hope you can all hear me.
Kindly note that it's only 10 minutes. The presentation is only 10 minutes. Okay, go ahead.
Thank you. So I will share my screen, but I will go very fast. Let me share, because I just think it helps sometimes when you're presenting. All right, so my presentation today is on the role of legal aid actors and what we can all do as part of this legal aid community in promoting access to justice as part of the response to the pandemic. I will not delve too much into the introduction. In terms of the meaning of legal aid, we all know that this is because it was a paper presentation. So of course, we started by setting the stage that legal aid is about legal advice, legal representation, and so forth, and the anchorage of the framework in the Constitution and in statute, which we are all familiar with. But here for me, the crux of my paper, the main reason I wrote this paper is to talk about the response by the government and some of the responses we've seen and how they infringe on human rights and how the state and non-state actors can play a role now in promoting access to justice, especially for the indigent and the vulnerable groups like persons with disabilities. So I will go straight into that bit because I think that's the great value add, and I'm sure a lot of people already have the framework down. So some of the responses we've seen to the pandemic, I'll go through some of them one by one and then talk about the human rights implications and then summarize the role of us as legal aid actors, whether it's state or non-state. So starting with some of these responses, we've seen that during the COVID-19 pandemic, we've had access to legal remedies being disrupted and the court system and the way it runs has been disrupted. So we now have virtual rulings, virtual hearings, and we know that a lot of cases are going on Zoom, on Skype, or whatever other platform that the judiciary is adopting. The problem with that is that not everyone has access to some of this infrastructure or to technology, and we know that internet penetration is still an issue in this country. So it's not automatic that if you move everything online, then everybody is benefiting from it. So So even though this was a measure that was meant to promote access to justice, for the most vulnerable who do not have access to technology, for them it is not a plus, it is a minus, because now you impede their access to justice. Another measure that we've seen that we are all familiar with, this is our reality in Kenya, is that there's been an imposition of curfews and travel restrictions. Even though some of these things have been changed from month to month as the COVID teams review the situation on the ground. So where we had curfews in place and where we had restrictions moving from county to county, and even at the beginning of COVID, we had international travel restrictions. Where these restrictions have been there, they were meant to curb the spread of the disease, which is understandable as an effort by government. But at the same time, we witnessed certain repercussions that were so horrible, and they continue to persist till today. And this is sort of some of the spaces that for us as legal aid actors, we can step in. So as a result of the curfews and the travel restrictions that we've seen, one of the implications has been police brutality. Police have shot people at the markets, people who are just returning home from work. The minute you're 1 minute late, it's a problem, and they deal with it with excessive force. We understand that there are laws that they must be abided by, but the police should not use too excessive force where they're even breaking into homes and shops, and there have been reports of looting that is going on. Even for the journalists who are trying to report what is going on in the country, you find they have been faced with police brutality as they try to report some of these incidences. These are some of the things that we've seen as a result of the curfew being imposed. Still on the curfew, we've also seen an effect that is interesting, which is a very negative effect on the delivery of reproductive, maternal, and newborn health services in Kenya. It's really important for women to be able to access facilities for delivery, for skilled care at birth, but this has been disrupted because of the imposition of these strict curfews. The interests and the needs of pregnant women and newborns have not been taken into account. Again, a negative issue that has arisen because of the imposition of curfews. There's also been gender violence, and the person before me, Dr. Mataywa, he did an excellent presentation on the South African scene, and in Kenya it's not much different. We have seen the imposition of the curfew actually elevate the risk of gender-based violence, so that since the pandemic has hit, there have been reports that now you have increased intimate partner violence, you have a spike in sexual violence, so that in many parts of the country, people are living in fear, and the perpetrators are actually members of their families, relatives, guardians, people who are actually living with these victims. So gender-based violence has been on the rise. Of course, there's also the strain economically on the family and on the breadwinners, and as the strain increases, we are finding that the partners are facing increased violence. So that's part of it. And also, so that's when it all comes to the curfew and some of the negative things that we've seen. Also, in terms of the health measures, now this is something that we all know about, the quarantine program that was there, that if someone was suffering from COVID-19, you were going to be quarantined. There was contact tracing that was taking place, and quarantine programs had been put in place. This is nothing new that I'm saying, we all know about it. But we also, the media and the reports, there were numerous complaints about the mistreatment of persons who were in quarantine, the fact that they didn't know when they'd be tested, when their results would be out, their sanitary conditions were horrible, the food was bad. So you had all these negative complaints going on, yet people were placed under mandatory quarantine. So of course there's a human rights issue. There was also excessive securitization, so that if you broke curfew laws, you were quarantined, maybe because you were found in a pub or religious institutions against COVID-19 rules. You also placed in quarantine under these same conditions and isolation of persons. It was some of these measures were also infringing on human rights, which I'll get to in a minute. Also for the vulnerable groups, and this is where also legal aid comes in. We saw a lot of vulnerable groups, persons with disabilities, the elderly. They're the ones who have been borne some of the biggest brunt of this pandemic. They're very disadvantaged, and yet they're not able to access justice. So these groups have suffered, and they, of course, need increased affirmative action. We are not saying that the actors have done nothing, but we need to increase the access to justice for such people. So in terms of the human rights violations that have been there, just as a result of the pandemic, we see that the greatest thing that ties it all is the lack of access to justice, that all these things happen to the indigent, the things that I've mentioned, to the vulnerable, and yet they're not able to access justice. Maybe because of cost barriers, because of various issues, lack of infrastructure, and the challenges that we know that sometimes are faced as a barrier to access to justice. They also have not had access to having the rights to fair hearing. We know the right to fair hearing is also a constitutionally grounded right for everybody. You find that arrested persons, especially when there are all these arrests taking place, they did not have their legal representation, they were not afforded their rights under the Constitution, and these were blatant violations that were taking place. It's true that a lot of non-state actors were there condemning these actions, which was great, but we know that this was a result of the pandemic. And my paper is just developing, then at the end it ties it in now with the legal aid part of it. There's also been infringements on the right to dignity, freedom and security of persons, where there's been very cruel and inhuman treatment by parties like the police. There's been infringements on the rights of people to health and to accessing information, where you're brutalizing the journalist. And as I said, this is a summary of quite a lengthy paper, yeah? It's 10,000 words, but I'm trying to summarize. So I think, again, now to tie that in back to the topic is, what is the role of state and non-state actors? We know for legal aid, there's the state that has a role to play. We know through the Legal Aid Act, we have the National Legal Aid Service, we have the judiciary, and in the morning we had a great talk about the role of the judiciary has been playing. We have the non-state actors, some of them are here in the conference, and the amazing work that you've been doing. And so I think this section of my paper is not to try to pretend that I am summarizing everything that we can do. This is a conversation where I would actually love input, and it needs collaboration by both state and non-state actors, so that access to justice is a key part of the response to the pandemic, that it is not put on the side, that we need to quarantine people, we need to put curfews, but we are not considering access to justice issues. So what can we do as representatives from the state and those who are in civil society organizations, etc.? I would be remiss if I didn't start with legal aid in itself, right? Helping the indigent and the vulnerable who've suffered from some of these cruel measures that have been so excessive, to get legal representation, to access remedies, and making sure that those who are not able to afford are given a chance to be able to go to court, and even to consider other measures. We had Professor Kameri Mbote mention traditional justice mechanisms. Thinking of ADR as a measure outside of the normal court system is something that we can do. As state and non-state actors, we also have partner to bring a case against government officials who used brutal and excessive case. That was fantastic, and we need more of that. More human rights groups mounting cases on behalf of the indigent and the vulnerable in the society. We also need public awareness campaigns, and I can see that I've run the 10 minutes, but I'm trying to summarize. We also have the public awareness campaigns where they should highlight the risks that are being faced by women, for example. How can you, what are the channels that you can use to seek help? These kind of things can be campaigned, not just through the radio, but even through social media. Earlier, again, we had the EU representative mentioning social media and how it can be used to dispense legal aid. Mental health has become a really big issue during this pandemic, so there should be increase in mental and psychosocial support to help victims of gender-based violence. There should be promotion of ADR. I'm a big ADR advocate. For those who cannot access courts, courts are not the end. There are other measures, and these should be promoted excessively during this period, so that people can, for example, go to chiefs or elders in their societies to resolve some of the disputes that they have. We should have GBV responses at national and county levels, free legal aid for that, for the GBV survivors. We know that some people, that the reason that there's so much violence is also a money issue. We should try where we have the funding to give cash money to vulnerable households, so that you can reduce the economic stress that they're suffering. and there should be collaboration between among various partners so that they can come together to see how to respond to some of these issues. So basically what my paper is about, and I hope I've given it justice in terms of a summary, is that even as people think about the COVID-19 response, the government, it is not possible to have these responses without considering access to justice being at the center of it and making sure that those who are disadvantaged, the vulnerable groups, are also given a chance to access justice. Justice does not belong to just the judiciary. It does not belong to us as actors, even for us who are academics in the law schools. It belongs to everybody in the society, and we should make sure that it is promoted. Thank you. That is the end of my presentation.
Thank you so much. From Riara School of Law, Florence Karimi Shako. I needed to have noted initially that we are with one of your ex-colleagues, Dr. Francis Hayundi, who will also be presenting here. And one of your ex-students also is also with us here. Asante sana. Now we are going to, can we have the presentation from Kellyn? Then after that we can have Commissioner Winnie. Kindly keep it to 10 minutes.
Relating to HIV and health. Kellyn was formed initially by UNDP in 1992, after nearly 10 years after the first case of HIV in Kenya. And our first response was clinical, medical, and there was a lot of stigma, and there was a lot of issues of human rights violations and ethics. And in 1992, UNDP called a number of people from Africa. They met in Ghana, and they agreed to form committees, legal and ethical committees in each country to address human rights perspectives. And that's how Kellyn was born. We will be presenting two papers, one on Friday, one today, on basically just sharing the Kellyn experiences on how we have provided legal aid through the courts for persons affected with HIV. That's the case we are presenting today. And how we have also provided legal aid in respect of traditional justice systems. That I will present on Friday. So Tim will present today's paper. Thank you.
Okay, thank you, Commissioner. So as introduced, Timothy Wafula, and I'll quickly just be presenting on Kellyn's use of, just a moment. Okay, just the experience of Kellyn in using legal aid to facilitate access to justice for people living with HIV and in Kenya. Maybe just a quick note, also to note that Kellyn is also part of the Keni wa Kenya grantees, and we have been working with other grantees just to enhance the capacities and just working together to discuss issues on access to justice. So, so I think, as Commissioner has noted, how Kellyn came to focus on people living with HIV stemmed from the fact that I think with this pandemic, just even with similar experience with COVID, since the HIV pandemic epidemic started in 1984, there's been a lot of legal challenges that have affected people living with HIV, issues to do with high levels of stigma, high levels of discrimination, human rights violation in employment setting, human rights violation in the community, and in all these, including gender-based violence affecting and targeting people living with HIV. So just as a matter of background, HIV is one of the major public health issues in the world. We have almost 38 million people who are living with HIV in the world, and in Kenya, the number is estimated at 1.5 to 1.6. So initially, the response to HIV mostly focused on the medical issues, whereby the response was focusing on clinical aspects of HIV, medical aspects of HIV, and I think then later on it was realized that given the high levels of social issues that were emerging, human rights issues, then there was need to shift the response to deal with the other societal issues that were impacting on the response, such that as the medical aspects were being addressed, also the social aspects needed to be addressed. And these social aspects included these issues that I've mentioned, for instance, discrimination in the families, community, schools, health facilities, sexual and gender-based violence, and also focusing on key and vulnerable populations in the HIV context. And in this context, we have had the epidemic concentrated on certain populations who are considered key and vulnerable, for example, men who have sex with men, sex workers, people are injecting drug users, and we now also have a high prevalence on adolescent girls and also women. So, yeah. So I think now the aim of our paper was just to share the experience of Kelly's model in facilitating access to justice for people who are living with HIV. So why one of the main reasons that we thought that legal aid is important in the context of HIV was given that when legal services contribute to creating an enabling environment where people access HIV prevention, treatment, care, and support services, people are able to claim and enforce their rights to access HIV services, and also problems that create vulnerability to HIV are addressed. So that's one of the main reasons why Kelly sees that there's increased need to ensure that people living with HIV as a vulnerable population are provided with legal aid. So also noting that effective legal aid can make justice and equality a reality for people living with HIV, and this contributes to better health outcome. So the model that Kelly has mostly employed in this aspect revolves is a three-tier model. One, targeting the community of people who are affected with HIV through training on training on to understand their human rights. So noting that when the community understands what their rights are, then they will be able to claim these rights. They'll be able to document violations. They'll be able to report violations. They'll be able to take action against violations that come about. So that's the first part of the model. Then the second part now involves working with lawyers such that once the community is empowered on their rights, then they have people who can work with them to facilitate access to justice. So in this context, the first part of the model works with training communities, empowering communities, having dialogue with communities. Then the second model involves now having conversations with lawyers, doing a training sensitization of lawyers just to understand what are the human rights issues in HIV, why do people living with HIV need to be facilitated to access justice, and what would be the role of lawyers in this context. Then the third aspect in that model would be now facilitating this connection, that you have a pool of trained lawyers, you have communities who who have been provided with information sensitized on their rights and who are actively documenting rights violations in the community, now connected with the lawyers so that we can have pursuit of justice. So again, in that context, you now realize that this model will only solves the individual cases of people whose rights have been violated. But you now also note that there are policy issues, legal issues, and issues at a larger scale involving the law, policy, and practice that might need to be addressed. And in that context, Kelly's model revolved around use of strategic litigation now to have to impact a broader, to influence broader change in the law, in policy, and in practice. So so in this context, you will note that in most cases, for instance, you will have an enabling legal, or you'll have a legal environment that protects the right, but the practice on the ground is different, such that you now need to have a strategic focus to shift the policy, the practice that is on the ground to ensure that it is consistent with human rights and that that the law the existing legal frameworks are implemented in a manner that will ensure that the rights of people living with HIV are protected. So in this context, Kelly has, for instance, in the initial stages, as Commissioner has mentioned, the founding members of Kelly worked with other people just to contribute to legal change through, for instance, in the task force that was looking into the legal and ethical issues revolving around HIV. That was established in 2001. That also led to the development of a law specifically addressing HIV related issues. That's the HIV Prevention and Control Act. So some of just highlighting one of the strategic cases, for instance, that Kelly has litigated to enforce the right to privacy of people living with HIV. We had the case of Kelly and 3 others versus Cabinet Secretary, Ministry of Health, and 4 others. This was a petition that was challenging a presidential directive where the president had directed that data of all school going children using a form that linked identity. Okay, sorry. So also it was also going to be collected in using the existing provincial administrative structures, yeah, from the chief. I don't know the new guys from the chief, the county commissioners, and all that. So again, that was an issue of concern. Maybe that collection of the data could have been a noble idea, but the manner in which it was going to be collected would invariably violate the right of privacy of the children and their parents, noting that there are still high levels of stigma associated with HIV. So using this case, Kelly sought to have the Ministry of Health and the National AIDS Control Council formulate privacy guidelines before collecting such data. So maybe a quick just one other case that I can highlight as I move towards the conclusion will be a case that challenged mostly the incarceration of people TB there's a correlation between HIV and TB, with TB being one of the major opportunistic infections for people living with HIV. And now the practice before was that because TB being an infectious disease, just like COVID, was that if a person defaulted on their medication, there would be a public health officer who would arrest the person, and this person could be sentenced to jail. So again, using strategic litigation, we had this practice challenged, and the resultant aspect with on this challenge was that we had the ministry develop an isolation policy, a policy to guide such to guide the ministry and health actors when such cases arise. And the policy even is very relevant at this particular time when we are dealing with the COVID situation, because one of the aspects was that there needs to be isolation centers established so that there's proper management of people people affected by TB. So the paper discusses most of these cases, including other cases that have been litigated by Kelly pro bono lawyers at the HIV and AIDS tribunal, touching on employment matters, insurance matters, testing without consent, and other issues. So as I conclude, maybe just to note, one of the main challenges that Kelly as an NGO has experienced in implementing this model is that, one, of course, strategic litigation takes a long time because it includes components of having community mobilization, media mobilization, education, making the model to be costly and also time intensive and all that. And also just conclusion of cases takes time. And given that the organization is donor funded, you have, for instance, an example, we've had a case that challenged the practice of forced and coerced sterilization of women that has been in the courts since 2014 and is yet to be concluded. So in conclusion, one of the main lessons we've learned is that in using litigation in using this model in facilitating access to justice for vulnerable communities, one, that there needs to be a lot of community mobilization, media engagement, so that people are able to understand their rights and they are able to mobilize on their own to be able to be active actors in this scheme. And also just that there's a very big need for affordable legal services if we are to address human rights violation, especially of vulnerable and marginalized community people in the community, and community members can be used and can be very essential in realizing legal reform. So that's essentially the paper. Will be having the full version shared. Okay, thank you.
Thank you so much for that presentation. From a presentation where we had one commissioner to another presentation where we have another commissioner, and now we are going to have Commissioner Winnie Lichuma. She's already online, and we are going to have her projected on the screens. And then after that, we are going to have let's call it the colossal plenary discussion, which will be led by a colossal scholar on matters of law, Professor PLO Lumumba. So over to you, Commissioner Lichuma. Kindly 10 minutes. Her paper is titled Legal Aid and Access to Justice, Agenda Analysis of the Kenyan Legal Framework. And thank you to everyone who's following us online. I see Masese Kemunche, Program Manager at Center for Enhancing Democracy and Good Governance, CGG in Nakuru. Asante. CGG in Nakuru. Asante.
Thank you, Chair, and thank you, Moderator. I hope you can hear me. Can you hear me?
Go ahead. Go ahead.
Thank you. Okay, so sorry, unfortunately, I couldn't be able to join you, but I will happy this mode of communication is there. And I'll just spend a few minutes. Of course, 10 minutes is quite little for me to outline what this paper is about, but I'll just give highlights. This is a paper that is under development. And why I got interested in this is because we have had legislation drafting in this country that has retained aspects that are gender neutral. And of course, when you have the gender neutrality, it then becomes a source of not implementing with a gender sensitive mind or in a gender responsive manner. So when I picked the Legal Aid Act, I think it's one of those acts I see its drafting being in terms of the neutrality, which as I go down and try to make recommendations, it would be very important that we get to understand how do we make gender responsive law making processes. It's no wonder that the two-third gender rule has never been realized in terms of even how the wording has been done. Even current, when you look at the BBI process and you see how the gender realization of the two-third gender rule is worded, you clearly begin to see aspects that are quite not responsive. So the gender analysis here is in terms of, we use the human rights framework, and thanks Florence Chako for laying that out in terms of the gender perspective of the legal aid. So having listened to the other presenters, we do agree that access to justice is a basic principle in terms of the rule of law. And in absence of access to justice, people are unable to have their voices heard, they exercise their rights, challenges around exclusion, aspects around equity and equality then become part of what we begin to look at. But for there to be successful legal aid programs, there must be recognition of gender-related obstacles. the equity processes that remain. I will also be looking at so far what the legal aid the program has been able to offer. And with this, undertaking that gender analysis, we'll be examining how the Legal Aid Act may not be that vehicle we require to see offering an opportunity to women and girls who require to get this protection so that they are able to access the legal aid. So the object of this study is to make recommendations in terms of the existing policy legal framework and the structures that they are, in terms of how do we make them gender responsive so that when they are employed in interpretation and in the implementation, the Legal Aid Act then becomes meaningful, especially for the women and girls who are very vulnerable. I think I have reached my 10 minutes. And one of the aspects I would then be using in this is types of discriminatory laws that exist that are quite getting, if the women and girls do not get the legal aid so required, the vulnerability around them will get to positions whereby if courts would have found otherwise, but without the legal aid, they may end up being victimized. So I can stop there for now, but I believe it will be an interesting paper once it is out.
Thank you so much, Commissioner Winnie Lichuma, for your presentation and for the humility to stop once you had depleted the 10 minutes. But of course, we shall be waiting for the full paper to read it in details. And with that then, ladies and gentlemen, then we are going to have Professor, kindly, technical guys, let's sanitize the mic before Prof takes the podium. So we are going to have Professor PLO Lumumba lead us in the plenary, and thereafter we shall call it a day.
The organizers and the financiers have been thanked times without number. I'll therefore not repeat the same thing. I intend to have this engagement proceed for no more than 15 minutes. I've been sitting for a long time. And I'll not repeat what has been said, but I'll remind you of the presentation that was made by Professor Kameri Mbote, because you remember there was no opportunity to discuss that paper. And some of the standout issues in Professor Kameri Mbote's paper was the highlight on how we ought to teach law at the universities and other post-university institutions. The standout words there were clinicians, decolonization of how we teach at the university. And I would want us to interrogate those issues, because she did suggest that we may have all the beautiful laws we want, but if we are not practical in the manner in which we instruct our young men and women, then nothing much will happen. And then we had the presentation that was made by Catherine. I think Timothy Wafula talked about Kellen. That is a very recent presentation, and you are aware of the issues that are there. The young Miss Shako also talked about access to justice, and Winnie Lichuma has also talked about the same. The gentleman, Dr. Busieka from South Africa, took quite a long time. I thought he should have ended after 10 minutes. He went for too long and covered quite a wide range of issues. And what I would therefore suggest is that we tease out the issues to the extent that they are deserving of attention. And let us remember that this particular session is focused on strengthening access to justice through legal aid. So the contributions and interventions ought to be understood in that context. I've not mentioned what was discussed by Atieno Amadi and what my good friend Professor Githu Muigai also said and what Dr. Gakeri said. So let me open the floor by way of inviting short, sharp questions. Charles, short, sharp. Any question to break the ice? Oh, you use that, yeah.
Yes, thank you, Professor PLO
Take
Lumumba.
4 questions and then they are responded to.
Was my dean at Kabarak Law School, not far from here. Regarding your colleague, Professor Kamere Mbote's presentation, one comment, I felt worried when she was saying we should abolish the judiciary because only a few people use it. I felt that there is a public good effect whenever there is a decision which is made. It is not consumed by a particular litigant, but it sets a precedent which applies and has a wider effect than to reduce it to just that individual who goes to court. It's not a private good. A deterrence effect and a precedent is created so the rest of us don't have to go to court. I thought that was something we could say for the judiciary. But on her other point, I felt almost like, I don't know what you would think yourself. Should the law be a second degree? Because what we are saying is we need to teach justice or social science such that just like medical doctors learn about disease, then they learn about the remedy. So we need to teach something to do with either morality, ethics, and put that as a primer, and then the law will be used as an instrument for social change. That's perhaps all I would say at this stage so that others can also contribute.
Thank you very much, Charles. Save to point out that I did not understand Professor Kamere to say we abolished the judiciary. She simply said that we ought to look at the role of the judiciary in the context of how many people use it. And let us not ignore the other things. It was before lunch, so I understand what may have happened. Thank you very much. Professor Wabwile, is there anything you'd want to say by way of enriching this conversation?
Thank you, Professor PLO Lumumba, my teacher at the University of Nairobi, and a colleague at Kenya School of Law and at Kabarak University. What I would like to say is that I really liked the comments of Professor Kamere Mbote because she said that we need to review the attitudes and values that we are imparting amongst the learners of law. I see the Dean of Law is asking me to put on my mask. All right, so there's something she said about deconstructing and overhauling the values, because she said if the students of law are being taught that practicing law is about making money and attending to, upmarket clients and getting the most out of clients who can pay 100 million, so that they have no time to listen to somebody who cannot pay their fees. That is a value system. That's a belief system, which you find in some law schools. I just want to assure the colleagues in this room that when we started the law school at Egerton University 5 years ago, I'm privileged to have been anointed to be the founding dean. We sat down with my colleagues and we said, what value system do we want this program to have? And you see our statement on our value system in the founding documents. We said our program, our LLB program, shall be focused also on human rights education, humanistic values, so that our students and graduates have a sense of solidarity with victims of violations of justice, violations of human rights. So when we go with these students in the outreach programs, I see them sitting down. We listen to people who have suffered violations of rights, and you can see the learners are actually crying with the victims of violations of rights. You can see when somebody is talking to us in those villages of Nakuru North, Subuki and so forth, where we go, people are telling us heart-rending stories. And then the students are crying. You can see, yeah, this is exactly what we want to see.
Thank you very much, Professor.
Thank you.
Yes. I want us, there's something that Ms. Lichuma said, which I would want to hear Catherine say something about. The argument, perhaps it wasn't very well developed. The argument which she says that when you look at the Legal Aid Act, to the extent that the language is gender neutral, that undermines the access to justice for women. Did I get her right?
I think you did.
Yes. I would want us to educate ourselves how that happens.
I think the point Winnie is making is, you see, when you make law, it becomes a tool that is interpreted by others. The lawyers mainly and the judges define what has been said in that law. And what they understand that they should deliver is the message in that law. So the meaning of words in law are crucial to facilitating access to justice for whoever it is supposed to deliver that justice. So when you use gender neutral language in a society that predominantly or has a default mechanism of delivering justice for one gender other than the other, then you facilitate the default, you facilitate the continuation with that mindset, bearing in mind that the lawyers who are interpreting that law, the magistrates and the judges who are interpreting that law are creatures of the society that has actually defined that way. So it helps when you are able to see in the wording of the law, when you are able to see a girl and a boy, then you can consciously define a solution for the girl and a solution for the boy. I think that's what she was saying.
Dan, you talked about something that you talked about in passing, about the Lilongwe Declaration. Of what value, practical value, would the Lilongwe Declaration have in terms of the theme of access to justice through legal aid?
No, I think basically the idea that we should be able to harness the normative frameworks that have been locally developed, including within our region, to ensure that we localize them. But most importantly, I think to the extent that the declaration talks about irreducible resource allocations that are required, if we take a whole of government and a whole of society approach, the different governmental, given that in this country we have two levels of government, can be able to allocate resources to ensure access to justice.
Yeah, thank you very much. I just want to bring another question on the table. This also came from Professor Kameri Mbote. And she said that there is wisdom in having people specialized so that you have clinicians. And if many of you remember, Professor Wabwile, you'll remember this, Moi University, I think, was established on that basis, that this would be a school of law that would be run differently. You would have students practicing, you would have student practice rules, you'll have insurance. Did you find practical wisdom in terms of that suggestion by Professor Mbote when we talk about Article 48, and then the practical role of legal aid? And that you could also say something, the manner in which we teach at the Kenya School of Law as guided by the Kenya Council of Legal Education. I want to hear some wise comment. Ms. Dindi, you are all the way in Garissa. What do they do in Garissa that is useful in that regard? Particularly the cultural aspects of it, I think that. And then Catherine will say something.
With regards to the culture, just repeat the question, Prof, again, one more time.
I'm saying that there was a suggestion by Professor Kameri that we want to be practical in terms of having people who are trained as clinicians.
Yes.
And I'm saying that even if that were done, and I gave the context of Moi University, which was established on that principle,
yes.
And I'm putting it to you, you who are in Garissa, where you have Muslim culture and that kind of thing, and
yes.
these things arise.
Yes.
What is your practical experience?
I hear what you're saying and what was proposed. It's actually challenged my thought about it, because when you go up to there are various cultures, various places in which, first of all, it's, how do I put this? It's a developing thought that I have, so bear with me. Okay, let me just allow me to finish the thought.
Yes.
If we fail to actually identify the actual needs, for example, when I'm in Garissa, I'm dealing with a number of monsters. There's a whole cultural aspect of the Islamic woman and what she faces, even with regards to accessibility to justice, and how it's predominantly a male patriarchal society. So even when she wants to access certain services, how does she access them? She has to go through not even the perception, not even her own perspectives, but even the male perspectives that are already there, the cultural perspectives of, do I have to ask somebody, a male person? So if we fail to actually recognize that culture is ingrained in Garissa, is ingrained in the northern frontier, then we lose them, because then before she comes to get any information from me or any legal services from any other legal practitioner, what does she have to go through to get to where we are? And I completely agree, actually. I'm just saying I completely agree with Professor Mbote's suggestion that we need to actually customize the clinics in light of cultural stereotypes that are already there in order to identify the needs and meet those needs of the people in those regions.
I hear you. As Catherine speaks, I also want, then you have something to say. Then you have, in that order, you say something, you say something, you say something, you say something. But I want these issues to be addressed. Remember, they talked about the plural legal systems. So don't forget about that. And also, Charles, I want you gave an example of something that happened in Kisumu about the murder cases. And I would finally want somebody, I'm not going to intervene, you just move as you finish. All these we are doing in the context of the theme of the conference, that we are saying that in order to strengthen access to justice, you need legal aid. And therefore, when you go into the villages, and Dr. Aura spoke about it, you are speaking to some chief amongst the Pokot. What is it that you tell the Pokot chief in matters of access to justice at that level? And what is it that you tell somebody else in Nandi, for example? You may proceed.
I agree with Professor Mbote that it would help if the law schools specialize. First, because I believe law is a service sector, as is economics, as is anthropology, that we exist to provide services in all sectors. I think, was it the DVC who talked about, who was pleading with the students to do something about law in agriculture. Now, if we go that way, we are likely to go in depth in terms of developing our own local expertise around an area. This has happened around the world. For instance, if you want a good arbitration school, if you go to Geneva, graduate school, they don't want to worry about criminal law, but they are focusing around arbitration, and you'll get the best knowledge around arbitration from that school. If you go to Stanford, it will be issues about technology. They'll give you the best, things like that. Nothing stops us from allowing law schools to delve into a sector deeply enough. And you see, once you delve into a sector deeply enough, you can shape policy, you can shape law, you will be able to tweak the different multiplicities of the systems that exist. You will look at the cultural aspect and so on. From Kellyn, we've been working on health. We began narrowly with HIV. We realized the bigger picture on addressing the right to health helps to deal with HIV. So we are now going broader. If you're talking about data protection, the solution you get for the HIV person is the solution you will get for the next person in health. So it helps to go broader than to just go narrowly. And I think the law schools would do as much better if they picked one or two sectors and did a thorough job in those sectors.
Thank you very much. We have 10 minutes to go, so when I give you the mic, take 1 minute. Yes, somebody else who is next in line, you can have that, so there is a relay race.
Thank you. I think, Prof, I will respond to the issues that has been raised about the career pathway for clinicians and law school specialization, and maybe just to start from where my friend raised about law being a second degree. We have tried that for years and years. It is not politically acceptable, and the masses have been very loud to tell us that we cannot prescribe law as a second degree. But the career pathway for clinicians is a conversation, Prof, we have had even with you in the task force and Professor Mbote. However, I think where we fell off the wagon is where we were suggesting that the candidates who, over the years, then who were about 7,000, had not passed the bar, and they were unlikely to pass the bar, that we would prescribe a pathway for them and they would get into legal aid and paralegals, because then we grappled with the definition of a paralegal. We were trying to figure out how do you even classify the paralegal, because there's that one in a corporate, there's that one in CSOs, there's the one in universities. We couldn't get it right. I personally believe that people who have not passed the bar should not be side or taken towards the path of paralegals, because then you lose the entire component of quality, even in paralegal services provision. I think we need to define a career path, and that can be done from legal education and training, where you're saying you have your LLB, you don't have to be a lawyer, you can be a career paralegal. And that's just something that the market, the Law Society, NLAS, ourselves, legal education providers, the state can help to define and craft a career path that then ensures that even the paralegal that you get holds 1 or 2 degrees in law. And finally, whether law schools should specialize deep enough to go to legal aid, I agree. I don't think it is common knowledge that the law schools in Kenya, all 17 of them running 19 programs, are different. They have got different niche areas, they run different programs, and they have different methodologies of delivery, they have different outputs and outcomes. So if we, like now Egerton has been able to churn his way, Moi University was on a very good path. The McKay report, that's the one Prof is referring to, the McKay report actually identified clinical legal education as a gap, which is what the Moi LLB was supposed to fill. And I guess now that it's on a right path, it's going to do that for us.
Thank you. The standout issue there, you had clear career path, second degree, of course, all of us know that it ought to be, but we don't want to. Political hot potato. Continue.
Thank you. Well, Professor Mbote also talked about having these cultural practices being embedded in the education system. And now she also mentioned we are funding the judiciary through the exchequer's money. Then we also need to look at the same for the traditional practices. So as a legal aid provider, if one is going to qualify for legal aid services, we should then use the same yardstick, the criteria to be used when one is being assessed. Do you qualify for legal aid? And what if it's cultural practice? Are we going to give legal aid for this? So that's an area I thought also was mentioned.
I think there is something else that was said which is the assumption always that when you talk about legal aid, you talk about people going to court. You're also talking about people selling land, and they just want simple.
Thank you. I would like to speak I'd like to compliment what Professor Mbota said on the need for us to have a change in the way we teach law. I'll just quote a paper. I think that will be the precise way of summarizing, being brief. There is a paper that I read today, non-state justice systems in Southern Africa. How should the governments respond, by Wilfred Schaaf. And this is relevant to the issue of decolonizing the law practice, or else we risk irrelevance. So there is one thing that really moved me. He said that he written in 1977 in Mozambique, after they gained independence, what the government did, they sent all law students from law school to the village. And then they spent like 1 year there to learn the ways and the laws of people. And then I think they came back decolonized. So we lawyers, we still have the same practice like our colonial masters did, and we've not endeared ourselves to our people and our culture. And this is our downfall. Thank you.
I think let us not assume that this is the last session. Some of these issues will emerge during the sessions tomorrow.
Yes, and then I will not be very long in what I want to contribute because they will be, they will be tomorrow. But it's a sneak preview that maybe people can respond to when I have spoken tomorrow. Prof, I work in a field which is international criminal justice where, for example, you know that in Rwanda there was Gacaca court and the human rights groups were saying that was not justice. Justice is the retributive justice. In northern Uganda, you have people who surrender to, they come out of a civil war, and the community says, let us do matoput. This is our son, why are you prosecuting him at The Hague? And there are right now 25,000 people just in the bush in the Central African Republic because they want to surrender, but they don't want to be prosecuted. So what I was wondering is this, and in terms of the Kisumu shootings case, I'll be illustrating a situation where the route of retributive justice and punishment, and then having reparations after that, seems to be a Western formal model. But in Kenya, we appear to have had a situation where people were able, a few people, were able to get some justice in the Kisumu shootings case, but without having a conviction before that. So the concluding point I'm trying to ask is this. Are the goals of customary justice identical to the ones of the formal justice system, or we are comparing apples and oranges? I'll be trying to illustrate that point and about victims' representation in that context. Thank you.
Thank you very much, Charles. Dr. Busieka, you said quite a bit about gender-based violence in South Africa. You want to say something by way of enriching this conversation?
My teacher at the law school, and I'm proud that down here in South Africa, you've been trending a lot of acclamation on social media. I belong to a professional group called Swane Professionals, and they keep posting and commenting positively on your what I can call outreach discourse that you have had around the continent. Having said that, but mine is just a quick one, and especially Prof, I need you to help if you can, and even those around the table. South Africa has been grappling with whether to introduce an extra year in law school to specifically look at the possibility of introducing what we call community work. You know, doctors, they attend 2 years community work before they graduate. And so I don't know if Kenya has got any thinking around introducing community work, which will, of course, then capacitate because we've been talking about issues of capacity for clinicians and pro bono and legal aid. They will essentially be working in this kind of establishment as a way. Of course, the issue of quality, as I've heard from the table, and professionalism may come in, but they can provide some serious research backup for those lawyers who are there. Are we thinking around that area? That's just a poster for me. Thank you, sir.
I believe that the Council of Legal Education, which is ably represented here at the Kenya School of Law, I think these are conversations that we have heard, but people want to finish and begin making money very quickly. So that is part of the problem. Winnie, can you say something? You spoke about gender neutrality. You want to amplify?
Yes, Prof. Of course, in 10 minutes, there's that much I would have said. But thank you, Catherine, for stepping in and strengthening that argument. You know, the argument here is when you're analyzing legislation with a gender perspective, and Kenya, we are unfortunate that we write law and sometimes then we go back to policy. Yet policy should be available for us to pick the issues that need to go into the legislative framework. And having said that, my guiding principles here on the responsiveness, which I'll try to explain, are basically looking at how do we understand the impact in terms of legal aid for men and women, boys and girls. So once we have established that, we then now need to get to examine that position in line with the law we are writing. At the point when we are examining these, there will be regional reports, country reports, and therefore, from my point of view, the impact on men and women in terms of legal aid is totally different. And if we didn't identify the inequalities that do exist in terms of the female gender, I expected then to see the law affirmative actions that clearly go onto the female gender to ensure that the inequalities do not exist. When you are having a law as the Legal Aid Act, and it's looking at men and women on an equal footing, not appreciating the inequalities, I don't then see the affirmative action that clearly says, we will do these services for men and women, but we'll go an extra mile in terms of affirmative action to ensure that the boys and girls are able to access justice. Let me just give you an example. In Kenya, sex between minors is prohibited. COVID has just shown us many girls who got pregnant. Who is getting these girls to go to report, to prosecute their matters? Who will stand for them when they get to prosecute their matters? So legal aid will not be given on the same footing for men and women, boys and girls. So I expected that affirmative action written within the legislative framework so that we are able to discern that the inequalities that do exist will now be addressed. Let me stop there.
Thank you very much, Winnie. Let me have two last interventions, Aska and then Mzee Badawi. I want to hear your perspective. After listening to all these, you'll say something. Aska?
Thank you so much, Prof, for giving me this opportunity. Because I really resonate with what has been said, because I've had at all those presentations. And I feel that the area of concern is mostly about me being a woman with a disability. And we've also talked about culture, because now for me as a female and as a woman with a disability being deaf, that's like double tragedy in terms of accessing justice. And we know that we have all these discussions ongoing, and I'm wondering whether, like we're talking about the reforms that needs to be done, maybe sign language needs to be one of the languages lawyers can learn. We've talked about them having outreach in the community, so maybe they should also come and be with our community, persons with disabilities, understand our culture, understand what they need to do. So it's easier for us to also reach out to them and access for we as a community can access justice, so that we are not looked at, as disturbing the society or being a burden, because even COVID has really affected us. And I hope that for these 3 days, we can really see how we can collaborate and ensure that justice is for all and no one is left behind.
Thank you. In the absence of Badawi, who was online, I think Dr. Gerasimos will have something to say. Say something. You must say something. Even if you didn't.
Yes, I think that it is fine with all these nice words and these bright ideas and the engagement of the congregation in bolstering legal aid and in discussing all these aspects. I think that our project may be able at some point to also add something to all this development. For the moment, we are struggling with quite a lot of red tape to kickstart our operations, but I would say we are very close now after facing a lot of delays. But if there is something to be ripped out of this experience and capitalized on, don't underestimate the difficulties in any kind of operation, in any kind of campaign that you may face because of undue red tape. Thank you.
Thank you very much. We conclude now. Flora, you have heard. I know you are working together. At least you are supporting Flora and her team. And you've heard that is not for the faint-hearted. And I think the value of the intervention that we have on this very first day is that is agenda setting. And the beauty of this engagement is that when we talk about legal aid, the Faculty of Law at Egerton University is actually on the ground. So it's not a theoretical thing. They are on the ground. And I think that when we continue to interact tomorrow, and we begin to get the different permutations. We have had the presentation from Kellen. We have had the presentation about gender-based violence. We have had Aska's intervention about persons with disability, particularly sign language. Sometimes we forget this. We have had Winnie Lichuma and the young Ms. Shako talk about, and even my good friend Catherine Muma talk about the need to be very specific in terms of the language that you use. So I think a lot of things have been placed on the table, and it would be presumptuous for us to begin to talk about things that will rise tomorrow. But from where I sit, I think this has been a good day. A lot of issues on the table. The rapporteurs, I hope you are distilling the issues properly, and that when the final day comes, they'll have been teased out and will be utilized in the manner that the Vice Chancellor, through her representative, suggested. May I now beg to conclude this session and to invite the Program Director to do so in a more formal way. Program Director, could you come and conclude it very quickly, aware that people are tired and some are hungry?
Yes, and perhaps to just request that we have someone following us online, and he had put a question that perhaps in a way we've already answered it, or maybe if we've not, we just ask his indulgence that we answer him in due course. This is Paul Masese from SEDGG. And by the way, SEDGG is one of the institutions in Nakuru who are running a similar project. I'm talking about the legal aid project. He's asking here, I need a comment from a panelist when Professor Mbote says, when you formalize the informal, you remove it from the people it is intended to serve. How does this sit with the newly enacted policy on AJS? I'm not sure whether we have time to answer or to respond to that now, but perhaps it has already been responded to in one way or the other. And if it hasn't, then in due course, we are going to request that he continues following the discussion, and it will by all means be responded to. So you see why I had initially said that we are going to have a very colossal panel discussion, which only needs to be guided by a colossal scholar. Can we put our hands together for a round of applause to Professor PLO Lumumba, please? Asante sana. And so that then I don't keep you waiting here, we have actually just come to the end of our first deliberations for the first day. Can we therefore call this sitting to a closure? And after this, we are going to have a cup of tea outside there. And then we had initially said that the dinner and networking session is going to take place from 6. It's about 27 minutes to 6. It's not going to be possible for that to really happen, and especially just after a cup of tea. Can we push it to 7? Madam Dean? Can we push the dinner to 7? Yeah. Or from the floor, or are we going then to skip tea and then we have... So let's just have suggestions, please. Is it okay if we have it at 7? Because we are just going for a cup of tea now. It is okay? Yeah, okay. So our senior has actually seconded that. So at 7, we are going to meet at the restaurant where we just had our lunch, and that's where we are going to have our dinner. So for now, we are going to call it off. Anyone to say a word of prayer for us? Okay, we can just say the grace together. May the grace of our Lord Jesus Christ and the love of God and the fellowship of the Holy Spirit be with us now and forevermore. Amen. So welcome to the cup of